Shortly after starting your lawsuit, I get a call from the defense attorney, the attorney who represents the two doctors whom you have sued. And you know what he says to me? "Hey, Gerry, can you tell me what this case is really all about?" Do I have to tell him what the case is really all about? Shouldn't he know this? Because we are opposing attorneys representing different interests. Do I have an obligation to tell him what the case is really about? Do I have an obligation to tell him what our expert thinks about his clients and what they did? You want to know the answer? Come join me on this walk on the beach as I tell you the exact answer. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The short answer is yes, I do want to tell him exactly what this case is about. And yes, I do want to tell him exactly what our expert has said about his doctors. Now you might be thinking, wait a second, why would you do that? He's the opposing attorney. If you give him that information, he's now going to have a leg up on you of exactly what's going on with this case. Well, let me share something with you that you may not realize. When the opposing attorney gets your lawsuit papers, in other words, here's what happens. We've confirmed with a medical expert who has reviewed all of your records that yes, you do have a valid case. So now we go ahead and prepare the papers necessary to start your lawsuit. We take those papers and we deliver them to the people whom you are suing. Those doctors or the hospital staff then goes ahead and delivers those papers, the complaint, to the attorneys who represent them. Now, those papers are not very detailed. They're not very specific. They don't lay out exactly what you are claiming in this case. So now the defense attorney picks up the phone, calls me, and assuming he has a working relationship with me, he says, "Gerry, can you tell me what this case is about?" And even if we've never worked with him before, and he says, "Hey, I represent the two doctors whom you have sued in this case. Can you tell me what this case is all about?" And the answer is, yes, I can. Let me share with you exactly what this case is all about. And now I'll proceed to tell him in a summary fashion, in one paragraph, of exactly what was done wrong here and why. Now, why is that important? Why would I go ahead and voluntarily, eagerly, voluntarily tell my opposing attorney, the defense lawyer, exactly what this case is about? I'll tell you why. You have lived with this problem for quite a while now before going ahead and starting the lawsuit. We, as your attorneys, have lived with the case for a shorter period of time, but at least we have a better understanding of what went on. Why? Because we've had the benefit of gathering all your records, reviewing them, and having a medical expert review those records. So we have a better understanding of exactly what was done and why, or what wasn't done. And now, the defense attorney, when he gets your lawsuit papers, all he has is that document. He hasn't spoken to his client yet. He hasn't reviewed any records yet. All he knows is the general allegations of negligence and medical malpractice in this particular document. So he wants to get a better understanding before he reaches out to his clients. And now, by telling him, by explaining to him, here's exactly what our claim is, now he knows and can have an educated conversation with his doctors about what our claims are. And you might be thinking, wait a second, why would I disclose to him what our expert has said? I'll tell you why. Because it's not a secret. It is critically important that I disclose to the defense attorney exactly what our expert has said. Plus, it gives us an advantage. It now alerts the defense attorney to the fact that we have had this matter reviewed by a qualified medical expert who feels strongly that we have a valid case. And now I begin to tell my opponent, I say, look, we have an expert who says that your doctors failed to recognize this patient's breast cancer on imaging. The radiologist failed to recognize this nodule that was sitting there and failed to recognize it on a mammogram. It's clear as day. Our expert went ahead and said, how did they not see this? That gives the defense attorney critical information that will help him when he also reaches out to the insurance company to explain the facts of this case and to explain our claims and our allegations. And if he has that information at the very beginning, it gives us a leg up and it gives us an advantage. I'll tell you where it also helps. If we wind up having settlement discussions at some point during the course of your lawsuit, now the defense has a very clear understanding of exactly what our claims are, exactly what injuries you suffered as a result of their doctor's carelessness, and now we can have an honest conversation about this particular case. We go ahead and claim that the doctor was careless. He didn't read these imaging studies properly. They're going to come back and say, what are you talking about? Our expert says just the opposite, that there's no indication that this was cancerous. There's no indication this was malignant. And now we have an honest conversation about his theory, his defenses in the case, as well as our claims. I find that some of the best defense lawyers in New York are the ones who utilize this resource, who actually pick up the phone to call to ask me those questions, Hey Gerry, what's this case really all about? I need to talk to my doctors, I need to reach out to the insurance company. Give me an idea. Okay, it involves a failure to diagnose cancer. In this case involving radiology imaging, where the radiologist failed to recognize the following things. And by the way, our expert clearly says, your guy screwed up big time. It's clear as day on there. How did he miss this thing? So why do I share this great information with you? I share it with you because nobody talks about this. People think that when they go ahead and bring a lawsuit, there are clear delineated sides. He represents that side, we're on this side, there's no talking to each other, it's very angry and antagonistic and aggressive. And you know what? Not necessarily. In many instances, behind the scenes, the attorneys are professional, they're polite with each other for the most part, and we have to work with each other. And learning this information at the very beginning is critically important, not just from your standpoint, but also from the defense's standpoint. You know, I realize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.